Hey guys, so I just wanted to get back on here because I have a case reading that I'm going to read today. Uh, this is, we will continue parts 3, 4, 5, and 6, or however many parts it takes to finish up the initial readings from the book that I've been reading to you guys from. However, I wanted to get on here and show you that uh, state Supreme Court actually did rule. There is actually a case where driving your automobile personally for personal use does not require a license. I actually found it. So all this going back and forth, bickering back and forth with each other and arguing and all that, uh, we getting ready to lay that all to rest. You know, you can even give this case to the police, and there ain't nothing they can do about it. There's not a goddamn thing they can do about it. All these police running around out here thinking that they got the upper hand, that they are the law, and that they can do what they want to do. No, they cannot. And I got proof. Okay, now granted, it is an older case. However, the case has not been superseded, nor has it been overturned. Okay, the case was decided, the charges was dismissed against the driver, and the fact of the matter is the ruling stands. So therefore, that's a ruled on case. That means that case and the decision was final. It made it in the law books. It is a law that was hidden. Let me show you this. Let me show you this. Let me show you this. Can you guys see that? Let the camera get in focus. It is trying. Just bear with it for a minute. It'll come in because I want you guys to see this. I got this straight out the books. I want you guys to be able to look this up yourselves. And it did go in focus when I had it, but now it's not trying to go in focus now. So let me see if I can make something get a little better here. I don't know. Oh, there it goes, there it goes, there we go, there we go. Now we're getting it. There we go, 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 there. Oh, oh, oh. Right here. Can you guys see that now? There you go. There it is. There it is right there. You guys see that? Man. Man. I'm telling you. Knowledge is power, people. Knowledge is nothing but power. A decided case that is in the law books, right? And I'm going to read the entire case to you because it's actually a short case. I didn't even realize how short it was until I actually started looking it up. And when I found the book and then I read it, I was like, oh crap, this case is actually pretty short. So in light of that, State versus Dunklee, Dunklee, 76 New Hampshire, 439 New Hampshire, 1912, decided June 4th, 1912. Now you say, well, god damn, Angel, that goes all the way back to the back. Yeah, you're right. Just like when people are arguing those 1915 cases. So now you have a 1915 case, right, that talks about licensing and how you can do this and do that, and you can attach a fee to it, etc., etc. But here you got a case that says no license is required, and everybody's always, but if you look back on YouTube a while back, I want to say that it was a bunch of the Sovereigns. I'm not going to actually put a title to any particular group that posted the picture of the Supreme Court justices up there talking about the Supreme Court has in fact ruled that you do not need a license to drive, no registration to drive, etc., etc. The interesting thing about that is they were right. They just listed the wrong cases. But they were right. They were correct. In fact, they were correct. 100% correct. And here it is. So I'm going to get into this case because what I want to do is I just want to get the point out there and get everybody to know that the Supreme Court actually did rule on this for New Hampshire, but it's still a Supreme Court ruling nonetheless, and it is very effective. Decided June 4th, 1912, a city ordinance which requires the licensing of hackney coaches, cabs, and other vehicles used for the public conveyance of passengers is applicable to motor vehicles so employed. Although enacted prior to their advent, the statute providing that no municipal ordinance which regulates the speed or restricts the use of automobiles shall have force or effect. Laws from 1911, 133 to 15. I'm going to assume that that's the state's, motor code laws or whatever. So we're just going to say that that's what that is. Okay. Shall have force. Let's see. Use of automobiles shall have force or effect laws. Does not deprive a city of the power to require the licensing of motor vehicles employed within its limits for public conveyance of passengers. There's that word again, employed. Doing business. Appeal from the decision of the police court of the city of Concord, which found the defendant guilty of violating a city ordinance requiring the owners of hackney coaches used in the city to obtain a license from the board of mayor and aldermen. The defendant has not complied with the ordinance and was engaged in operating with a chauffeur as driver, an automobile or taxi cab carrying passengers of the city. The defendant is guilty if the ordinance applies to the transportation of passengers for hire in motor vehicles transferred from the October term 1911 of the Superior Court without a ruling. Okay. The ordinance upon which the prosecution is based is as follows. No person or persons shall set up, employ, or use any hackney coach, cab, or other vehicle for the conveyance of passengers for hire from place to place within the limits of the city without a license from the mayor and aldermen. And the question presented by the defense is whether this ordinance applies to one engaged in the business of conveying passengers for hire within the city of Concord in a taxi cab. The validity of the ordinance as applied to the business of transporting passengers in cabs or hackney coaches is not questioned, nor is it contended that the use of taxicabs as a public means of conveyance does not require, for practical purposes, the same supervision or regulation by the city as the use of hacks in the same business. The evident purpose of the ordinance, which was enacted in 1894 by virtue of authority granted to the city by Section 10, Chapter 50, Public Statutes, was to regulate and supervise the business of public carriers of passengers upon the streets of the city for the convenience and safety of the public. The license is required when one engages in that business and not when he uses a hack or a taxi or other vehicle for his own accommodation. Again, I will read that again. Public Statutes was to regulate and supervise the business of public carriers as passengers upon the streets of the city for the convenience and safety of the public. The license is required when one engages in that business and not when he uses a hack or a taxi cab or other vehicle for his own accommodation. The particular name or designation of the vehicle is not important, but the character of the business in which it is used is important and determines the question whether a license is required under the ordinance. In other words, the ordinance does not purport to regulate or supervise the mechanism of vehicles that are allowed to use the streets or to authorize the mayor and aldermen to determine the kind of motive power that may be used in the propulsion of carriages upon the public highways. It is only the business of public conveyance in vehicles of some kind that is subject to the supervision of the city. As the object and scope of the ordinance is thus limited, it has not been impliedly repealed by the legislator in Section 15, Chapter 133, Laws of 1911, as is claimed by the defendant. The chapter relates to the licensing by the Secretary of State of persons to operate upon the highways of the state, automobiles and motor vehicles, and establishes certain rules or regulations as to the speed and management of such machines. It does not purport to regulate the business uses to which motor vehicles may be put. Its purpose is to supervise and restrict their management while they are being propelled upon the public thoroughways. Section 15, upon which the defendant specially relies, must be construed in view of the general purpose of the Act. As above briefly indicated, it provides that no ordinance by law or regulation now in force in any city or town or in any park or parkway which regulates the speed at which motor vehicles shall be run upon its ways, or which excludes such vehicles therefrom, or which governs or restricts the use of such vehicles, shall hereafter have any force or effect. Was this language intended to have the effect of depriving cities of the power of regulating and supervising the business of the local transportation of passengers in taxicabs? While the ordinance governs or restricts the use of the defendant's taxicab in relation to the business he employs it in, it does not govern or restrict his use of it as a carriage or vehicle upon the streets, meaning his personal vehicle. He's taking his business vehicle and using it as his own personal contrivance. Yes, he can do that. Does he need a license to do that? No, he does not. Let's see. Okay. Let's see. Vehicle. Carriage. Use of it as a carriage or vehicle upon its streets. In this latter respect, he is subject to the provisions of Chapter 133, which do not apply to the business of carrying passengers, but to the management of motor vehicles, whether used for pleasure or pecuniary gain. The word use in the statute was not intended to have so broad an effect as to prohibit the regulation by a city of the occupation of hacking within its limits, because it was carried on by means of motor vehicles. A Commonwealth versus Newhall, 205, Massachusetts 344. Otherwise, it might be said that the fact that a peddler carries his goods about in a licensed automobile makes it unnecessary for him to obtain a peddler's license under Chapter 76. A somewhat surprising proposition, all the evidence bearing upon the question of the intent of the legislator leads to the conclusion that the ordinance was not repealed, with the exception of one word in the statute, which might by a forced construction lead to an opposite result. But as statutory language is not always given its broadest meaning, or a meaning which the context and subject matter show was probably not intended, Pierce versus Emery 32, Carter versus Whitcomb 74. The evident intention of the legislator was as revealed by the act cannot be defeated by giving a single word in the statute an unnecessary meaning. The claim that the ordinance does not apply to the business of carrying passengers in taxicabs because at the date of its passage such vehicles were not in use cannot be sustained. Bly versus Railroad 67. Rockingham County versus Chase. As already suggested, the kind of vehicle is not important upon a reasonable construction of the ordinance. It cannot be doubted that a taxicab is a vehicle, and when people are carried in it for hire, as they are in an ordinary hack, the proprietor must obtain the license required by the ordinance in order to legitimately prosecute that business in the city of Concord. Whether the defendant was properly licensed to operate taxicabs under the state law need not be considered. This case was discharged. All judges concurred in the finding. There you have it. Point blank and simple. It puts it out there. It lets you know that, you can even use your business vehicle as a personal vehicle, and as long as you're not conducting business in that business vehicle, you're not required to carry a license for it. So it has been established. It's there. It's interesting that that case has actually come about, because I was actually interested and shocked to see it. This was the case that I was reading in part 2, an excerpt from the case, and the part that I had read was actually the part of the license is required when one engages in that business, and not when he uses a hack or a taxi cab or other vehicle for his own accommodation. When I read that part, I was like, that's got to be too good to be true. Somebody inserted that into the case to fit their agenda. You need to go investigate that. Well, I went and investigated that, and I'll be damned. I'll be damned. It's in the case. It's actually in the case. It's part of the case. It is actually part of the case. Yeah. So, I was so shocked when I saw that. Now, granted, you're going to get a lot of people that are going to say, well, Angel, that case is so old. Doesn't matter. It doesn't matter how old this case is. It doesn't matter how old it is, people. That's the point. The point is the case came from the Supreme Court of New Hampshire. It's a Supreme Court case. It's a Supreme Court ruling, which affects all federal regulations. Yeah. So you didn't know that, did you? Huh. All Supreme Courts, state Supreme Courts, the Supreme Court, affects federal. All. And that's just not federal for that state. That's federal for all states. So there you go. So you have it. So now you can actually see that the Supreme Court actually did, in fact, rule on that. And they actually said that a license is not necessary. So, like I said earlier, you can go, you can actually show that case, and it actually does work. Let me rephrase that. I don't know if it works. I haven't never used it because I just found it today. So with that being said, having just found it today, I do know one thing: it will be implemented into future paperwork. It will be inserted in there, and it will be inserted in there respectfully and forcefully, because it is a case that has been decided on. They made their ruling. They found the man not guilty. They decided that they didn't even have to look at the fact that he already had a license to operate his business, which was a taxi. Okay? What they were looking at was the fact is the matter that he was using his taxi as his own personal accommodation, and they ruled in his favor. So the case, I should say, you can't change that ruling. That ruling's for forever. That ruling's forever. I mean, bless the soul of the individual and the individuals who govern that case. I mean, they're all long gone, and in their respective places, you know. But on the same strength, you know, it is a ruling nonetheless. It is a ruling on our side. It is a ruling to our favor. It is a ruling of power. It has statute. It has standing. So that power, that statute, that standing is a case that will forever be printed in history. You know? And, you know, I don't know too many of y'all that know that case. I've never seen it online. It's never come up when I've cross-referenced other cases. And the interesting thing is when you look up the right to travel cases, you know, and they actually don't really, the cases that you see online, they don't really go to the right to travel with, well, actually, to be honest with you, you don't really see too many cases on there that actually address the issue of right to travel without a license. You know, the cases you do see on there with right to travel without a license actually address it in a manner to where someone had actually altered that case and wrote it to fit their agenda. Now, UCC 9-109 specifically says that if you decide to adore your automobile and that of the property, okay, if you're going to do it in property, then it is not a requirement as property to register your motor vehicle. True. That is true. And that is law. You know, and you can go that route. You know, you can go that route. There's so many routes that you can actually take to prove that you don't need a license, to prove that you don't need, you know, this, that, and the other, and what have you. There's so many routes to that. And the thing is, you know, we have an opportunity to pick which argument best suits our situation. You know, in reference to this case here actually fits everyone's agenda. It fits everybody's agenda. There should not be one single individual that is out there right now, okay, that can actually say, well, you know, I don't know, that probably wouldn't work for me. Why not? It's for you. That case is actually for you. So, you know, yeah, that case is actually for you. You know, so I mean, I don't know how you could deny it. The case is right there. It's in black and white. I just showed it to you. This is the case. There is nothing. There's no disputing that. That came straight out of the books. That came straight from the books. You know. So I mean, you guys, you want something to dispute. You want something to argue. But this right here, I read this and cut this video for that purpose, because I wanted to prove to you that the Supreme Court actually did say it. The Supreme Court did say that you have a right to drive without a license. You have a right to travel without a license. They said it. It is a done deal. So for anyone alleging, no, it's not, yes it is, it's a done deal. And you can cite this case. State versus Dunkley. It's in writing. It's a fact. Not a delusion, not a fantasy, fact. So for all you constitutional traitors out there, you trolls, you know, guess what? If you refuse to believe what I say, I'm putting this up here so that you can go and look it up yourself. Look this case up. Read this case. And if you still have questions or denial, then that just means you're just stupid. Because there's no way that you can read this case, okay, since you always want to throw case law up in front of people's faces. There's just no way that you can read this case and not believe that it actually has been done, and not believe that it can be done again. It will be, I promise you that. We are looking at a free society eventually. Eventually, it's going to come to that. Because I'm going to tell you right now, it's coming. We're here. We're here to stay, and we're coming. You know, we're going to fight for these rights, and we're going to win. We are going to win. Because one, there's too many of us. There's too many of us out here. And, you know, whether you approve of it or not, it don't matter. What we believe in matters. We the people. And we believe in our freedoms. And we believe in our rights. And we're going to stand on them. You know, evoke, demand, protect. Where no policy or statute was written, therefore no law shall be enforced, and no jurisdiction exists. Remember that. I'm out of here. Dark Angel's out of here because I just wanted to share that case with you guys, get it on record so that everybody can see it, because I want the fallout, I want the comments, I want whatever's coming, I want it. So, with that being said, deuces.